Robinson versus Chief Constable of West Yorkshire, clarifying police duty of care, tort law in 2018. The UK Supreme Court made a landmark ruling in Robinson versus Chief Constable of West Yorkshire. Police, reshaping the understanding of police liability and duty of care. This case answers a key question. When can the police be sued for negligence? In this video, we explore the gripping real-life events, the legal principles at stake, and why this ruling matters for both law enforcement and the public. Imagine walking down a quiet street minding your own business, when suddenly you are knocked to the ground in a struggle. But the people wrestling in front of you are not criminals fighting. They are the police making an arrest, and you are the one who ends up in the hospital. That is exactly what happened to Mrs. Robinson in the UK, and her fight for justice changed how the law sees the duty of care owed by the police. This is the story of Robinson versus Chief Constable of West Yorkshire Police, the case that redefined police negligence. Background story. The incident took place in Huddersfield, West Yorkshire. Mrs. Robinson, a 76-year-old woman, was walking along the pavement when two plainclothes police officers attempted to arrest a suspected drug dealer in her path. During the arrest, a scuffle broke out. The officers and the suspect collided with Mrs. Robinson, knocking her to the ground. She was injured and claimed damages against the police for negligence. The police argued they had no duty of care in this situation because imposing such a duty could lead to defensive policing and hinder their law enforcement role. Issue. The central legal question was, do the police owe a duty of care to members of the public when performing their operational duties, such as making arrests? And can they be held liable if their actions cause foreseeable harm? Rule. Traditionally, English law applied a restrictive approach to police liability in negligence. The Hill versus Chief Constable of West Yorkshire 1989 case had established a principle, often interpreted as granting the police immunity from negligence claims in the course of investigating and preventing crime, except in exceptional circumstances. However, the modern test for duty of care, as refined in cases like Caparo Industries versus Dickman 1990, looks at foreseeability of harm, proximity between parties, whether imposing a duty is fair, just, and reasonable application. Mrs. Robinson's lawyers argued that her injury was foreseeable. The officers should have known their actions could cause harm to nearby pedestrians. She was in close proximity to the incident, and it was fair and reasonable to expect the police to take care to avoid injuring her. The police contended that operational decisions should not be second-guessed in court and that a general duty of care could hamper effective policing. The UK Supreme Court, led by Lord Reed, disagreed with the blanket immunity interpretation of Hill. They clarified that the police are not exempt from liability in negligence for their positive acts that cause foreseeable harm. The arrest here created a danger to Mrs. Robinson, making the duty of care applicable. The court held that this was not a case of failing to prevent harm caused by a third party, where duty is limited. It was a case where the officer's own actions directly caused harm. In such cases, standard negligence principles apply. Mrs. Robinson won her claim. Conclusion. Robinson versus Chief Constable of West Yorkshire Police 2018 confirmed that police officers owe a duty of care when their positive acts cause foreseeable injury to a bystander, just like any other person. The case narrowed the scope of immunity previously thought to protect the police, and reinforced that no one, not even law enforcement, is above basic negligence principles. Mrs. Robinson's case proved that accountability does not stop at the police station door. Her persistence didn't just secure compensation for her injuries. It reshaped the balance between public safety and individual rights. The next time you hear someone say the police can't be sued, remember that sometimes they can, and they should.